All right. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Single Justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning on this beautiful, if cold, January 18th, 2022. Welcome to the Massachusetts Appeals Court. I'm Justice Joseph Didkoff, and I'm presiding over this single justice hearing. In accordance with the directives from Chief Justice Budd and Chief Justice Green, this hearing is being held virtually, but it is being live streamed on our YouTube channel. I want to welcome everyone who is watching us on the YouTube channel. There's only one case today. It is Children's Health Rights of Massachusetts versus Hanley, number 21J599. Before we get going, this is a petition under General Laws 231, Section 118, Paragraph 1 for review of the denial of a preliminary injunction. And before we get to the meat of that, I would like to acknowledge we have 10 attorneys here. They will not all be speaking. Some of them are representing school districts and are not planning on presenting orally, but many of them are. Attorney McLean, could you just state your purpose here?
Thank you, Your Honor. Attorney McLean, I represented the Family Freedom Endeavor and the People's Freedom Endeavor, which is an unincorporated association with over 300 involved parents with respect to the same Department of Elementary and Secondary Education mask policy, as well as some individual representative parties. We did file a notice of appeal for the full panel. However, I obviously have a vested interest in being here today, and Attorney Foho, who is handling for his clients the one of the same issues, is going to be handling the argument for the single justice appeal today.
Well, you're very welcome. So you're pursuing a appeal under 231, Section 118, second paragraph to a full panel of the denial of the preliminary injunction?
Yes, Your
Honor. What's the status of the assembly of that?
It hasn't been assembled yet. I called, I think, a week or so ago. I've ordered or attempted to order a transcript, and I'm going to be trying to speed the process up in the Hampden Superior Court the best I can.
All right, so you're awaiting transcripts. That's very helpful to know. All right, thank you. You're very welcome here.
Thank you.
All right, so let me ask you, Mr. Foho, and you should introduce yourself for the record.
Thank you, Your Honor. May it please the court. My name is Robert Foho, and I represent Children's Health Rights of Massachusetts and Citizens for Medical Freedom.
I've noticed that you've also filed a notice of appeal on behalf of Children's Health Rights of Massachusetts and Citizens for Medical Freedom. Is this that appeal, or are you also intending to be, obviously be able to participate in Mr. McLean's appeal, but are you intending that to be a paragraph 2 appeal in addition to this process?
That's correct.
All right. All right, well, that takes care of the preliminaries. It is your motion, Mr. Foho, a petition. So why don't you get it to it? I'll just say that I have read all the memoranda. I have gone through the appendix. I have 9 pages of notes. So I'm very familiar with what's in front of me, so you can jump right into it.
Thank you, Your Honor. I think the most important issue in this process is the issue of authority. 5 days ago, the United States Supreme Court in National Federation of Independent Business versus Department of Labor, that is the decision that stayed OSHA's vaccine mandate for large employers. The court stated that the Secretary of Labor, quote, lacked authority to impose the mandate. Administrative agencies are creatures of statute. They accordingly possess only the authority that Congress has provided. And we all know that the authority in that case, the text of the Agencies Organic Act, provided OSHA with a specific set of responsibilities for regulating occupational hazards and safety and health of employees, not issuing broad health measures. That case, Your Honor, in this case, they're not about face masks or COVID-19. These are disputes about the authority of state and local governments. The same principle articulated in that decision applies here in evaluating whether DESI, the school districts, and the two municipalities in question had the authority to issue these mask mandates. They too are all creatures of statute, and they accordingly possess only the authority granted to them. They do not have generalized or inherent powers. In Massachusetts, an administrative agency such as DESI has only the powers, duties, and obligations expressly conferred on them. Municipalities may exercise any power or function conferable on them by the legislature, so long as that power is not inconsistent with the Constitution or a statute. These institutions have guardrails, okay, and they're required to stay in their lanes, even in a pandemic. Now, cases in other jurisdictions that we cite in our papers, they've concluded that school districts and agencies under similar governing authorities lack the express authority to issue broad health measures such as mask mandates. The Sitten case out of Arkansas issued a TRO against a school district mask mandate because the district lacked the authority to do so. And the Corman case in Pennsylvania, which was affirmed by the Pennsylvania Supreme Court, that was a decision declaring an order by the acting secretary of the Pennsylvania Department of Health, another mask mandate, void and unenforceable because the acting secretary lacked the statutory and regulatory authority to issue the order. And now we have, of course, the United States Supreme Court issuing a stay of an OSHA vaccine mandate on the same basis. There was a lack of statutory authority to issue that mandate. Regarding DESI, the Superior Court's order cites no statute, rule, or regulation that expressly permits DESI to enact a face mask mandate. Rather, the court and DESI rely on the language in Chapter 69, Section 1B, that DESI has to ensure that students attend classes in a healthy and safe educational environment and other broad grants of authority. But the decisions I just referenced expressly reject similar reliance on these broad grants of authority. As for school districts and municipalities, the court's reliance on the Home Rule Amendment is unavailing. That amendment concerns procedural freedom. It does not provide a municipality any authority it would not otherwise have. Likewise, their reliance on similar broad grants of authority is misplaced. The same decisions I referenced reject that approach. These institutions, we need to remember, Your Honor, they have only the power that we, the people, give them. Whatever is left, we reserve for ourselves. A school district's authority is governed by Chapter 71, and the town's authority is governed by Chapter 111, Sections 31 and 122. For school committees, nothing in Chapter 71 provides them with the authority to pass broad health measures. They have specific authority to develop certain safety measures like general health, the general mental health needs of its students, school safety patrols, highway safety stations, internet safety measures, but no broad grants of authority, or let alone any other specific authority to issue broad health measures such as mask mandates. For towns and their health boards, their governing statutes clearly address sanitation issues and those types of problems within their borders, not broad public health issues like these. So there is no statute, no rule or regulation.
Let me ask you this. Which school districts do you perceive as having their own independent mask mandate, as opposed to one they just issued when DESI told them to? And there's obviously Cambridge, but besides that.
I don't have that list readily available. I could look for it, but I think that question is, or the answer to that question is largely irrelevant, because DESI directed these school districts to vote on a mask mandate that was consistent with the guidance it provided. So whether or not a school district came up with its own mask mandate before DESI issued its mandate or after, these school districts still enacted their own mask mandates and are responsible for what they voted on. Does that answer your question, Your Honor?
So you believe that the mask mandates, even the ones that followed the DESI guidance, also need to be adjudicated? I can't just assume they will disappear by themselves.
Absolutely. I don't think you can assume that they would disappear by themselves, because these mandates were voted on at school committee meetings and became essentially orders or measures passed by those school committees themselves. So just because if, for instance, DESI's mandate was held to be invalid, these school committee mandates will remain in place.
Let me ask you the converse of that.
Sure.
If I conclude that that DESI had the authority to give the order it did, do I have to adjudicate the power of the districts?
If DESI had the authority to do what it did.
Right, we just discussed if I decide DESI didn't have the authority, and you believe I still have to adjudicate the school districts. If I decide DESI does have the authority, do I need to decide whether the school districts have the power to do what they did?
I think it would be difficult to conclude that DESI has the authority, but the school districts do not. Essentially, the same analysis applies here. Do these governing statutes provide these institutions with the specific authority to enact these types of measures? If you were to conclude that DESI does have the authority, I think that requires a comparison of both sets of statutes, but I think it's difficult to adjudicate one without the other because the same analysis applies.
Okay.
The bottom line regarding authority is that there's no statute, there's no rule, there's no regulation that permits school districts or municipalities to enact these mandates. And they themselves also conflict not only with the Department of Public Health's statutory and regulatory scheme, but also the Constitution. Regarding preemption, the Superior Court concluded that there is no evidence of an express legislative intent that municipalities may not impose health-related rules in their own schools. But that standard is far too narrow. The standard governing preemption is much broader. A municipal regulation need not, or rather, the legislative intent to supersede local enactments need not be expressly stated for the state law to be given preemptive effect. Rather, a municipal regulation can be invalidated where the local regulation is so frustrated by the state statute as to warrant the conclusion that preemption was intended. So if you have legislation that deals with the subject comprehensively, it can be inferred, reasonably inferred, that it was intended to preclude the exercise of any local power or function on that same subject area. Here, the Department of Public Health has a, yes.
I'm sorry, I was just about to ask the question. You jumped right into answering it. So please continue.
Sure. The Department of Public Health has a comprehensive statutory and regulatory scheme concerning infectious diseases that broadly requires it to take various actions when a dangerous disease actually exists. For example, it has to investigate the pandemic. It has to provide certain healthcare services and resources. It has quarantine powers, but nothing in Chapter 111 or in its regulations requires the use of face masks to prevent the spread of coronavirus. It has an entire, frankly, very exhaustive set of regulations that specifically require the use of masks for certain types of outbreaks, but not the coronavirus. The Department of Public Health issued an order last May in which it required face masks in certain congregate settings, but not in schools. So this framework is comprehensive. It's well thought out. The department has the expertise and the authority to address these issues, and it does not anywhere provide for the requirement of face masks in schools or municipalities.
What do I do with the fact that I have an affidavit from the DPH medical director of infectious diseases saying that that DPH has advised SE that mask wearing is recommended?
That's not an order or a statute or a rule of any kind. That's merely an advisory affidavit rendered by a public health official that has no, we can all agree that's not a law. The department has.
Do you believe the DPH has the authority to mandate masks in schools?
We're not here to decide that issue today, but I don't believe that that's true. I think the department nevertheless has a comprehensive scheme that provides it with many different sets of powers to address an outbreak of an infectious disease, and whether and to what extent in the future it may promulgate a rule that requires masks. I'm sure we can deal with that and the circumstances under which it's promulgated and issued, but we don't have such a rule right now. And in fact, we have an extensive set of regulations that it calls them droplet precautions for various types of diseases and viruses. And for several diseases and viruses, it does require the use of masks to combat spread, but not for the coronavirus. And I think that's very telling in this instance, particularly when it comes to preemption and whether any local regulation in this same subject area is precluded or preempted. What's equally frustrating is that in rendering the conclusions below, the Superior Court relied on many hearsay statements contained in public health pronouncements and other communications by public health officials. This is inappropriate. Hearsay evidence is inadmissible. We all know that. It's classic evidence 101, but for some reason.
I'd like you to, something I wanted to ask you. You listed 4 statements that you characterized as hearsay, but they all seem to be supported by direct evidence. The mandates were created, tailored, and implemented in consultation with medical experts. The mandates were guided by DPH, other public health authorities, and medical experts. The working group in Cambridge consisted of scientists, doctors, educators, and families, and recommend that masks be required, and that CDC and DPH have recommended mask wearing. So those all seem like statements based on the evidence. So where's the hearsay?
There's no evidence to support those statements. There's no evidence in the record below to support those statements. Those are recommendations by public health officials and public health agencies that the court relied on to conclude that COVID-19 justifies the mask mandates at issue and presents a compelling need for them. But there is no direct evidence in the record to support any of those statements. None of those officials that uttered those statements were present at the hearing below. None of those officials submitted affidavits. None of those individuals or officials were testified at the hearing below. These are all recommendations in public health pronouncements that you and I can Google that the court relied on, that the defendants relied on, but
why aren't experts and government officials allowed to rely on this kind of information? I mean, your experts seem to rely on studies they didn't conduct.
Well, under the Dauber standard, experts are entitled to rely on studies and other widely accepted opinions in their field when proffering an opinion, and they're allowed, and they may be cross-examined as to those opinions and conclusions. We proffered 2 experts who were both available at the hearing, and certainly the defendants had the opportunity to cross-examine them. So pursuant to that process, it's totally appropriate to rely on that information. But when a court or a party merely relies on a generalized opinion or statement from an official or an individual who is not present in the courtroom, it was not been subject to that process to test the veracity of that opinion, that presents a significant problem under the rules of evidence. And such statements do not fall within any recognized exception to the hearsay rule. The Massachusetts Supreme Judicial Court recognizes that a record of a primary fact made by a public officer in the performance of an official duty is considered an exception to the hearsay rule, but evaluative reports, opinions, and conclusions contained in any public reports, and none of these statements came from such reports anyway, those are also not admissible. So there's no exception or scenario here in which any of the recommendations or the opinions that the court relied on below should have been admissible. They're not evidence. They don't fall within any recognized exception to the hearsay rule. And in fact, the numerous instances in which the CDC recently has contradicted itself demonstrates how dangerous it is to rely on these statements in a court proceeding. We as attorneys cannot test the veracity of these statements, and instead the proponent of the statements, here the defendants, can simply pick and choose which statements support their position and then rely on them. And then we're left to deal with the fallout.
Speaking of experts, I didn't see Dr. Bostom's affidavit in the appendices you gave me.
That was not our expert. Attorney McLean may be able to speak to that. Our experts were John Diggs and Tammy Blakesley.
I didn't realize that. Okay, that makes total sense.
Not a problem. I'd like to just briefly address our constitutional claim. The only case in the country that I'm aware of that addressed the claim that a school district mask mandate violates parents' constitutional rights to direct the care and upbringing of their children concluded that parents not only have that right, it's a fundamental right, and a school district's mask mandate infringes on that right. The Superior Court below essentially ignored
Arkansas case you're referring to?
Correct. That's a sit-in case from Arkansas. The Superior Court below dismissed that case because it's obviously not from this jurisdiction, but it's the only decision that I know of that has squarely addressed that issue. There's also a lot of reliance placed on Jacobson versus Massachusetts, and I'd like to take a brief moment to address that. I think that reliance is very misplaced. The Supreme Judicial Court in Desrosiers acknowledged the district court's rejection of Jacobson, County of Butler versus Wolf, which is a federal district court case out of the Western District of Pennsylvania, because it applied a far too deferential standard to an unrelated constitutional challenge, and agreed, this is the court in Desrosiers agreed that Jacobson should not lead us to disregard constitutional scrutiny and defer completely to the executive's orders, which is what's been going on a lot with these cases. Jacobson is also inapplicable here. In Roman Catholic Diocese of Brooklyn versus Cuomo, Justice Gorsuch penned a very helpful concurrence that essentially decimated the reliance that's been placed on Jacobson because it involved an entirely different mode of analysis, an entirely different right. This is a case from 115, 116 years ago, and an entirely different kind of restriction. The court essentially applied rational basis review to a vaccine mandate in that instance that contained an opt-out either way, under which you would pay a criminal penalty. The plaintiff in that case also advanced essentially a substantive due process challenge, which didn't even exist then. Griswold hadn't even happened. Griswold was 40, 50 years away. So Jacobson really has no application here. If you were to accept that the mandates here infringe on a parent's constitutional right to direct the care and upbringing of their children, then under strict scrutiny, these mandates fail. They don't serve a compelling government interest because there's no evidence in the record that COVID-19 poses any threat to the health of children or that masks have ever curbed the spread of COVID-19 in this state or anywhere else. And we proffered two experts that opine that face masks do present a threat of harm to children, and there is no evidence in the record to refute that. As far as the harm, the issue of irreparable harm, if you were to accept that our clients' statutory and constitutional rights have been violated, then we've established a presumption of harm. But even beyond that, the only evidence in the record on this issue demonstrated that the prolonged use of masks can and would harm children. There's no support in the record for the defendant's contention that adjoining mask mandates would expose children to the risk of contracting COVID-19. Indeed, if we were
Well, it's not accurate to say there's no evidence of that. I have the affidavit of Dr. Madoff, who's the medical director of the DPH Bureau of Infectious Disease, that says both those things, that it does prevent spread and that it doesn't cause harm.
the evidence in
Doesn't
the
change the fact that you have your own experts, but I don't think you can say there's no evidence in this record.
the evidence, well, if you look at these statistics from the Commonwealth's own public health website, its own state mask mandate that never prevented the curve. It never prevented the spread of COVID-19. In fact, cases spiked immediately after that mandate was instituted. But there's very little evidence that mask mandates have prevented or curbed the spread of COVID-19. And there's certainly very little evidence that this virus has done any real harm to children in this state or elsewhere. So we are requesting that this court reverse the Superior Court's decision on our motion for preliminary injunction. If the court has any other questions, I'd be happy to address them.
No, that's great. You covered everything I wanted. You took exactly 20 minutes, which was about what I was going to give you. So that's perfect.
Thank you.
So we will next hear from AAG Weitzel, who's representing the DESE, Department of the department here.
Thank you, Your Honor. Richard Weitzel, Assistant Attorney General for the state defendants, as you just said. May it please the court. For the last 2 years, the state defendants have tried to keep the education of the Commonwealth's children on track in the face of an ever-changing crisis. They determined that the best way to do this big picture is to try to maximize the amount of time children spend in the classroom and to minimize, to the extent possible, remote learning, which can be potentially harmful effects on children's educational and emotional well-being. The school mask requirement that's at issue here is one measure among others designed to achieve this educational priority. As the Superior Court below found, it was unambiguously within the power of the state defendants to impose such a requirement. Under SJC precedent, the state defendants have not only the right, but also the duty to ensure that students learn in a safe and secure educational environment. The Massachusetts Education Reform Act grants to the State Board of Elementary and Secondary Education broad and far-reaching powers. And those are the words of the SJC, not mine, Your Honor. Broad and far-reaching powers to establish policies relative to the education of students in the Commonwealth and to quote unquote establish standards to ensure that every student shall attend classes in a safe environment. And I'm quoting from Section 1B of Chapter 69.
You believe that authority is constrained or maybe informed by the regulations, or is it freestanding?
I'm sorry, which regulations are?
Well, so let's say 603 CMR 27.01, which, or 0.18, which deals with safe environment.
Well, Your Honor, I think that the statutory authority stands on its own as granting powers to the state defendants to create reasonable guidance and rules in the area of health and safety. And I think the mask requirement represents a straightforward exercise of that authority. Plaintiff's argument here really boils down to the idea that the power of the state defendants to regulate activity in the classroom comes to a screeching halt when the measure touches upon student health. They even try to distinguish the power of the defendants to regulate safety versus health, when these are really just two sides of the same coin. And as the Superior Court found, that argument, it's not only inconsistent with the language of the Education Reform Act, but it also defies common sense. You can't separate the quality of a student's educational experience from that student's mental and physical health. One comes before the other. And I think that's the commonsensical reaction that the Superior Court had. And it's all the more true, certainly during a pandemic. I do want to reemphasize, Your Honor, that the mask requirement was instituted for educational purposes. It's designed to maximize in-person learning during the pandemic by minimizing the spread of COVID in the classroom as much as possible. It's not a general health measure that the state defendants have decided to impose upon students simply to improve their overall health. And contrary to what you've heard the plaintiffs argue, it makes no difference that there's not specific statutory language that empowers the state defendants to implement a mask requirement. That's not how enabling statutes work. It's not how they're interpreted. As the SJC has said many times, agency powers can be expressed in broad or general terms, and the statute doesn't have to enumerate every single act that can be done in furtherance of such powers, and it would be unrealistic to expect the legislature to do that. So the question, as the SJC has said, is whether the authority here can be reasonably tied back to the language of the enabling statute, and that it's not irreconcilable with that language. It's a very deferential standard, and it's easily met here looking at the language of Section 1B. If I could, Your Honor, I do want to speak to plaintiff's preemption argument.
Before you move on to that, I would like to hear you on that.
Sure.
Do you agree, my reading of Chapter 71, Section 55A, is that a school system has to send a child with COVID home. Do you agree that that a child with COVID has to be sent home, can't stay in the school, whether or not you think that particular statute is the basis for that?
The student with COVID has to be sent home, Your Honor?
Cannot be allowed to be educated in the school, has to be sent home until they've recovered.
I believe that's correct, yes.
All right. And do you believe that the statutory mandate to allow children to attend classes in a safe environment, if they have to be sent home, that's inconsistent with that? I mean, in the sense that they have to, you have an obligation to keep students from being, to the extent you can, in a situation they have to be sent home and can't be educated in school.
I'm not sure if I understand the question, Your Honor. I mean, I think under the statutes, the state defendants have the right, the authority to try to maintain a safe classroom environment. And if a student has COVID, then it makes sense that that student would not attend class. Otherwise, the point is to try to, if it's unknown as to whether a student or students may have COVID, then the mask requirement is a sensible way to try to prevent transmission of the virus.
I guess what I'm trying to understand is DESE's obligation solely to protect the health of the children or to make sure that they can attend school? Obviously in a healthy environment. But
The two are entirely interrelated, Your Honor. You can't have one without the other. I mean, obviously, the overriding objective of the state defendants is to provide a quality education to students in the Commonwealth, and they've decided that quite sensibly the best way to do that is to try to ensure that students remain in the classroom. And to do that, to provide a quality education, they're trying to minimize the amount of COVID spread in the classroom. It all ties together. And I think the plaintiffs are trying to segregate the idea of health and safety requirements from the board's educational mandate. And these are all, as I said, one follows from the other. So I just don't think there's any conflict there whatsoever. And it's in this case, what the state defendants have done is implement really a commonsensical requirement that applies in many different environments. It's not much different from other commonsensical requirements like physical distancing, like hand washing, hand sanitation. And again, it all comes back to, we're trying to keep students safe, trying to keep them healthy so that they can attend school in person. On the issue of preemption, Your Honor, I won't belabor the point, but as far as the state defendants go, it appears that the plaintiffs are trying to sort of apply this concept of field preemption to the state defendants. And it's not a concept that applies when you're talking about two different state laws or either statutes or regulations. When state laws address related topics, courts attempt to harmonize them, to give them effect to the extent possible, all of them effect. So unless there's some, as we've said in our papers, unless there's some direct conflict between either a law that relates to DPH or something that DPH has done by rulemaking, there is no preemption issue here. And I won't spell out why I think there's no conflict, although I'm happy to answer questions on that, but there's simply nothing in the regs or the statutes governing DPH that speak to whether DESE can implement a common sense mask requirement in schools. It's two different topics. But as Your Honor alluded to, the preemption argument is particularly invalid here because DESE and DPH have worked together to put this school mask requirement in place, in the sense that DPH advised DESE on this topic. DPH has publicized the school mask requirement. They issued a joint letter/guidance document, both DPH and DESE, that spoke about the mask requirement. So the idea that there's preemption here simply doesn't make sense. Let me spend, if Your Honor is okay with it, I do want to spend a moment on the Supreme Court case that my brother alluded to.
Got about 2 minutes left.
Okay. I would just say that case is really far afield from what we're dealing with here. It involves the interpretation of the federal OSHA statute and what exactly is the definition of an occupational hazard. And the court there found that it has to be sort of occupation specific. Again, nothing to do with the statute, obviously nothing to do with Massachusetts law, this particular statute. And again, this statute provides broad powers, and it specifically talks about the right of the agency to establish standards to ensure that students attend classes in a safe environment. The Supreme Court also applied the so-called major questions doctrine in that case, which is a federal doctrine. It has absolutely nothing to do with state law. It's a doctrine, as Your Honor may know, that holds that when a federal agency is trying to essentially implement powers that have a quote unquote vast economic and political significance on a nationwide basis, that Congress is supposed to speak more clearly in that situation. What we have here is obviously completely different. And the Supreme Court, particularly the concurrence, ironically spoke about the fact that the powers to regulate in the area of health and safety are traditionally left to the states. So the Supreme Court essentially is trumpeting the power of the states in the case that my brother has cited, which has absolutely no applicability. I'll just end, Your Honor. I won't spend any time on the constitutional issues. There's a new case coming out every single day, it seems, that completely rebuts everything my brother said on the constitutional issues. There is no fundamental right here. It's merely subject to rational basis review. There's got to be 25 cases that have said that. I want to spend 1 minute, Your Honor, on irreparable harm, but I'll stop if I'm going too far.
I'll give you 1 more minute.
I do think this is a really important case where the balancing of harms must be taken into an account. I don't think Your Honor needs to reach that issue because the plaintiffs here have no likelihood of success on the merits. But if the court were to reach that issue, you're talking about the public interest here and potentially in joining this mask requirement during a surge in cases, the Omicron variant. You're counterbalancing that potential risk versus really, when you look at the plaintiff's papers, they do not identify any harm to any particular child that they represent. They make some broad general statements, but there's no concrete suggestion that any child that they represent is being harmed by this. And if any child they represented did have a medical issue with wearing a mask, there's an exemption in the policy, Your Honor. So I'll end with that.
That was a pretty long minute.
Thank you, Your Honor. I appreciate it.
Let me just, before we go on to the next person, I just want to say that the principles of Rule 16L apply here. And anyone who wants to give me case sites for cases that have come out since you filed your memoranda, all of you should feel welcome to do that until I issue the decision. Attorney Mello, you represent most of the school districts. How about you go next? So reset my clock here. All right.
Thank you, Your Honor. Peter Mello, Murphy, Hussey, Toomey, and Lehane. We represent Hingham and Attleboro school districts, but as Your Honor correctly notes, are presenting on behalf of the fellow school district defendants in this case. Just very briefly, at every juncture in this case, the petitioners have sought relief that even in the most friendly or favorable circumstances would be rare and exceptional. And in these is just flatly foreclosed. They asked that the Superior Court reach the extraordinary conclusion that despite the presumption of validity that local regulations enjoy as a matter of law, the vast and expansive scope of the Home Rule Authority, the complete absence of any statutory prohibition in this regard, and juxtaposed against the explicit statutory authority conferred upon local school districts, which I'll address in a moment, that somehow state law preempts local school districts from imposing these measures. They asked that the court eschew a vast and prolific body of legal authority throughout the country that respectfully they've essentially sought to bury in the record or even conceal from this court's review, whereby courts throughout the country at all levels have found and affirmed categorically the constitutionality of school district mask mandates. They asked for this relief via a preliminary injunction without remotely establishing a likelihood of success on the merits or identifying even a single individual, as my brother from the Attorney General's office correctly points out, who might suffer an imminent or non-speculative harm. Notwithstanding a vast body of CDC guidance of which courts have either approved or taken judicial notice, both in refusing to enjoin mask mandates and enjoining their prohibition, actually. They asked that this court exercise perhaps its most scarcely invoked power to conclude on single justice review that in declining to indulge these extraordinary requests, the Superior Court abused its discretion. And in advancing all these requests, they actually contradict their co-plaintiffs who admitted unequivocally at the PI hearing that school districts wield this authority to require face coverings. And I'm mindful that Your Honor recognizes that if DESE wields the authority to impose the mask mandates, the court can stop there and affirm the Superior.
I was just about to ask your opinion on that, so thank you.
Yeah, well, and I know we discussed this earlier, and I'm mindful that the court recognizes it. I think it's, in fact, if I understood my brother, Attorney Fojo, to admit that basically that as if DESE wields the authority, the court can stop there without even needing to determine whether school districts wield that authority independently. And I think the Attorney General's office is.
Do you agree with him on the flip side of that even if DESE lacks the authority, that I should assume that the school districts, maybe all of them, but certainly many of them, would maintain mask mandates themselves?
Whether they would or not, I guess, is a question. I know that some of the districts preceded DESE's mandate with their own parallel mandate. So some may not. I'm not sure how districts would deal with that. I think that they would have the authority, irrespective of what the court finds with respect to DESE's authority. But then conversely, if the court concludes that DESE has the authority, it can affirm that the Superior Court's ruling on that basis without determining whether the school districts wield it independently. I think the Attorney General's office has laid out copiously and quite well the bases that support what I think is an incontrovertible Superior Court decision. So I don't want to belabor this or impose on the court's time unduly with duplicative legal argument. And to that end, I think we can really confine our piece of this to two additional salient points. First, school districts unequivocally wield express statutory authority to impose these mandates. Numerous provisions of Chapter 71, including sections 37, 37H, 68, all broadly confer upon school districts the general charge and superintendents of their schools and the ability to regulate matters of safety therein. The SJC is defined or characterized that power as broad and ample, and recognized explicitly, actually, that it encompasses within its scope the ability to protect students from exposure to contagious disease. And I think candidly, Your Honor, that proposition or power would derive from, basically from common sense, fundamentally, even if it weren't explicitly conferred, as it is. In the plaintiff's or petitioner's world, no power exists unless it's been explicitly prescribed or enumerated in some paint by numbers instruction manual. And aside from the folly of that proposition as a practical or policy matter, as a matter of law, it's flat wrong, and their own case law contradicts it. Among the most fundamental axioms of Massachusetts municipal law, actually, is that local regulations are presumed valid and are invalidated only where there's an express legislative intent or where the local regulation would so frustrate the purpose of a statute that that intent has to essentially be implied. Courts are loath to reach that determination and do so sparingly and in the most, in the rarest of circumstances. And those at issue here don't remotely suffice to compel that sort of a conclusion.
I'd like you to wrap up if we can.
Oh, sure. So I guess I'll move on to, with respect, just very briefly, with respect to the constitutional issue. And I guess the only other point I'll add with respect to that last piece is that I want to emphasize the Superior Court correctly concluded that the DPH doesn't foreclose or prohibit school districts from imposing mask mandates or prohibit in any way school mask mandates. In fact, conversely, they worked with DESE in promulgating the one at issue in this case. With regard to the constitutional piece, the local school district's exercise of their constitutional authority here isn't remotely unconstitutional. And I'm not sure I've ever argued a case, in fact, so buoyed by such a vast concentration of supporting case law. In fact, in our PI papers, we cited to a National Law Review article that posited whether, given their beleaguered and dubious track record, these types of claims might constitute inherently Rule 11 violations. No constitutional state or federal provision empowers parents to thwart school districts from undertaking to protect their students from the rampant spread of a contagious disease.
I think that's a little excessive to invoke Rule 11, but in any event, you're well over the time I have, so give you one more sentence.
Oh, sure, Your Honor. Thank you, Your Honor. I think that covers it. I don't mean to suggest that we're not alleging or even seeking fees in this case, but I think that statement from that reputable source in and of itself is compelling and bears emphasis. And courts throughout the country have found categorically that these school mask mandates are wholly constitutional. And we respectfully request that the court affirm the Superior Court's conclusion to the same effect in this case.
All right, thank you very much. I understand that Attorney Grammel is going to be speaking.
Yes, Your Honor.
Who do you represent?
I represent the town of Dover and their Board of Health.
All right, go ahead.
So good morning, Your Honor. My name is Sean Grammel. I'm from the firm Anderson and Krieger, and I represent the town of Dover. I agree with everything that my brothers, Attorney Weitzel and Mello, have said about preemption and the constitutional analysis. So I'll focus my brief remarks on the authority of the Board of Health to issue the mask mandate. The Superior Court did not abuse its discretion in finding that the board acted well within its authority in issuing this mandate. Under Section 31 of Chapter 111, boards of health can issue reasonable health regulations. I'm sorry, Your Honor, my video is very choppy, so if you're,
I'm hearing you fine.
Okay.
Your video is choppy, but I have no problem hearing you.
Okay, good. The SJC, in interpreting Section 31, has found that boards of health can act as long as there's any rational connection or conceivable basis for what they do. And here, Dover's Board of Health looked at the rise in COVID cases over the summer of 2021 because of the Delta variant. They looked at the guidance from the CDC and the DPH. They looked at the studies that suggested that wearing masks slows the transmission of COVID. And then after looking at all of that, this politically accountable board that has subject matter expertise held a public hearing. And for over an hour, had questions and comments from the public, and then it made a policy decision. It issued a mask mandate. And there's a conceivable basis for what the board did. There's a rational connection between the problem that the board was facing, the evidence that they considered, and the action that they took. This is why we have boards of health. Boards of health are designed to protect the public health of every member of a community. They look at the entire population, and that's from American Lithuanian. You can't slice and dice the population and say, well, this segment would be fine. Boards of health are designed to protect everybody. And that's what this board did. And so the board would ask Your Honor to please deny the petition for the same reasons as the Superior Court did. Thank you.
Thank you very much. I very much appreciate that that was not repetitive of your brother's arguments. So I think the last attorney we're going to hear from is Attorney Bayer, who's representing Cambridge.
Thank you, Your Honor. And I will also keep my remarks brief because my brothers representing other defendants have already addressed many of the arguments. But I'm here to speak briefly about the City of Cambridge's mask order. The Cambridge Public Schools also had a mask mandate and are complying with the DESE order, but that is all part of the argument you heard from Mr. Mello. But apart from that, the City of Cambridge in the late summer, early September issued a mask order requiring that masks be worn in public places. And you heard from Attorney Grammel about the authority of a Board of Health to issue such an order. And the City of Cambridge's order is similar to the Town of Dover's order in that regard. One small distinction in Cambridge, there was a special act that established a commissioner of public health rather than a board of public health, but gives the commissioner of public health all of the authority that a board of health has. So the commissioner was acting under that authority. Also, the city manager under the city's charter, it's a Plan E charter, and the city manager is the chief executive of the city. And the city manager was acting under the authority given to local municipalities, to political subdivisions under the Civil Defense Act.
Well, that's something I had trouble following because it seems like the Department of Civil Defense of Cambridge would have to be involved to invoke the CDA.
So, Your Honor, there is a section of the Cambridge Municipal Code. There's an ordinance that does establish an emergency management department. That department under the ordinance falls under the authority of the city manager. That department has not been staffed and doesn't regularly take any action in the city. Just like the Civil Defense Act itself has so infrequently been invoked since its enactment in 1950, the need for the local civil defense body in the city there has not been a present need, so that it hasn't been in place, although the power is there. So in the absence of that, because it falls under the authority of the city manager as the chief executive, he is vested with that authority from the Civil Defense Act to act under Section 13 of the Civil Defense Act. In any event, it was both the commissioner and the city manager who've taken action, and they both have separate authority. One issue I want to clearly point out to the court is we've heard about the preemption analysis and heard from others about the general analysis that a local body can act as long as there hasn't been a clear intent to preclude them, or as long as the state scheme doesn't occupy the entire field and implicitly prevent local action. Here, where it comes to a board of health or the commissioner in Cambridge acting as the board of health, not only is there no sharp conflict to preempt local action, But the state action, the Massachusetts Department of Public Health action, has explicitly authorized local action. And I think that's an important point. So the plaintiffs cite to Department of Health regulations at 105 CMR 300. And they talk about how in those regulations, there's a section that addresses isolation and quarantine requirements, and the requirements that both the State Department of Public Health and local boards of health have to implement if they're addressing the isolation and quarantining of people with certain diseases. And one of the diseases, as Attorney Foho noted, is infection due to novel coronavirus. And he argues, well, in there, it doesn't require mask wearing. However, if you look at 105 CMR 300-200, the clear, unambiguous, explicit language is that those are the minimum requirements and that additional control measures may be required. Additionally, and I didn't cite this in the papers, but I would draw the court's attention in that same section 300.200, after you go through the chart of what measures are the minimum measures for certain diseases, you get to subsection C, which says, in addition to the practices set out above, the department, meaning Mass Department of Public Health, adopts by reference a standard practice for infection control, the most current version of the guidelines on the prevention of transmission of diseases by the CDC, which has come out in favor and in support of mask wearing and mask as a mitigation strategy to prevent the spread of COVID. So here, the city's order is not in conflict with the Department of Public Health statutory and regulatory scheme. And what's more is it's explicitly authorized.
I kind of need to wrap up.
Yep, and so just one quick additional point is Attorney Foho had said there's no evidence that masks stop the spread, and nothing in the record to refute his points about potential harm from mask wearing. And Your Honor did point him to DPH's expert affidavit. And I also would just point the court to the affidavit of the Cambridge Commissioner of Public Health, Dr. Asad Sayah. And Dr. Sayah has an affidavit that was submitted, and it's in the record at page 817. And Dr. Sayah is a Harvard Medical School faculty member, the CEO of the Cambridge Health Alliance. And he does talk about, in his opinion as the Commissioner of Public Health, that there is no harm to the wearer of a mask, and wearing masks has been determined to be safe and effective, not reduce oxygen levels or increase carbon dioxide levels. And in fact, in Cambridge, when the mask order went in place on September 3rd, there was a drop in cases in the weeks after that. Obviously, things are different now that we're in the surge with Omicron, but there, that supports the effectiveness, and it was part of the record before the Superior Court. So for all the points that everyone on the defendant side have raised, I would also ask that the court affirm the Superior Court's preliminary injunction decision.
All right, thank you. Attorney Froho, we don't usually have rebuttal here, but the other side went well in excess of the time I gave you, which is understandable considering how many there were. So if you'd like a little more time, you can have it. You certainly don't have to take it.
Thank you, Your Honor. I can address just a couple of points very briefly that came up. Number one, I wanted to follow up on your question concerning the Madoff Affidavit. That affidavit does not undermine any of the arguments that we provided. It addresses cumulative statistics concerning COVID-19 and fails to address the very specific and minimal impact the virus on children. And there's also a study that Mr. Madoff relied on in his affidavit that addressed the impact of the mask mandates on schools in 2 Arizona counties. But that study is misleading. For one, it addressed a period of time during the summer when the large majority of those schools were closed. Number 2, it intentionally conflates case data derived from zip codes rather than case data derived from the schools themselves. And it also, the third problem with that study is that it does not account for the size of the schools and its comparison of the data. So that affidavit is in our opinion, largely unhelpful. The other issue I wanted to address is that in the arguments that followed me, the question that continues to be insisted upon is, does anything prohibit what we've done? That's not the right way to approach this. The case law rejects this. The many court decisions on this issue address this. The appropriate question is, where is the authority to do this? That's the right question to ask, and that's how to approach this. And I'll leave you with that. Thank you, Your Honor.
All right. I want to thank everyone today. I've gotten some really helpful argument, and I certainly got some very helpful briefing. I've got another hearing tomorrow, but I will start working on this after that and try to do it as quickly as I can, though it's obviously is a lot to take in, so it will take some time. But this has been very helpful to me. I want to thank Mr. Conley, who's been running the Zoom room, and thank Clerk Stanton and his entire staff for allowing us, enabling us to have the technology to have these hearings in these times. And with that, we will be adjourned until tomorrow at 10 a.m. on this same channel, where I will have 2 other single justice hearings. So thank you, and thanks to everyone who's watching.